first speaker for today is a distinguished speaker. Richard Newman is the executive director of the American Museum of Tort Law in Winstead, Connecticut. Mr. Newman practiced trial law himself with the firm of Adelman and Hirsch in Connecticut, and he is the co-author of the standard treatise on Connecticut law of torts. And in addition to everything else, he served as the past president of the Connecticut Trial Lawyers Association. So I would like to welcome to the stage Richard Newman.
Good morning. My name is Rick Newman, and it's my great pleasure to be here speaking to you about the need to educate the public on the importance of tort law. And we start with the old legal maxim, ignorance of the law is no excuse. When you're hauled in before a judge, the judge will tell you, ignorance of the law is no excuse. But we keep people, for the most part, in ignorance of the law. So here briefly is what they didn't teach you in school. Tort law is the law of wrongful injuries, and that requires two things, obviously. One, an injury, and two, it must be caused wrongfully, either by an intentional act or a negligent, careless act or some sort of reckless act. Tort law has its roots in English common law from centuries ago, 800-900 years ago, when, as Ralph just alluded to, end the practice of blood feuds and duels with broadswords, they started having courts. And they did something very clever, which is they resolved disputes with juries. Common people, people like us, were the jurors who decided what was fair and just. And that is why it's called the common law. It's the law of the people, not imposed from the top down, but growing from the ground up. Tort law has three purposes. The one that people know, I got to get me a lawyer, is to get money, to be compensated for the wrongful injury. So compensation is an important part. But the other two aspects are disclosure of the wrongdoing and deterrence. A jury verdict can resonate around the country and indeed around the world to stop or halt or change unsafe practices. One of the remarkable strengths of tort law is that it is direct action. You don't need to get government approval or authority. You don't need a permit or authorization. It's directly created and started at the insistence of an injured plaintiff. It works on the basis of a contingent fee so that the plaintiff, the injured victim, doesn't pay the lawyer unless he or she receives compensation. Tort cases are done in open court. It's on the record. It's all under oath. The press can come in. The judge is there to apply the rules of evidence. All the testimony is subject to rigorous cross-examination. And if there's a mistake, it can be appealed to a higher court. Trial by jury in tort cases is as fair and safe and impartial as humankind has ever devised. So why is this important? It's important because the way tort law has evolved levels the playing field. It not only allows direct action, but it lets people without resources take on anyone in the world, any giant corporation, any overreaching governmental agency. The great historian Eric Foner, at the opening of the American Museum of Tort Law, which I encourage you to all to visit, called tort law the weapon of the weak, and that is a really insightful, powerful phrase. It lets an injured victim take on anybody and hold them accountable. To quote the Wizard of Oz, it levels the playing field between the great and powerful and the small and meek. So why is the American Museum of Tort Law so important? Why the need to educate the people so important? I think there are two reasons for this. First is because this system is self-actuating, tort law only works when people use it. As I alluded to a minute ago, tort law has benefits beyond compensating the injured victim. As a result of tort law, products are safer, autos are safer, roads are safer, toys are safer, food is safer. Tort law really serves as quality control. So it makes sense that the American people should be educated about and learn about how tort law and trial by jury work and benefit all of us. The second reason is that for the last 30 or 40 or so years, tort law and trial by jury, and to some extent the whole legitimacy of the system of civil justice, have been under attack. There have really been two prongs to this attack. The first has been legislatively. It's in the guise of what was called tort reform, which is a misnomer, was this notion that somehow a system of law that had worked perfectly well for 700 or 800 or 900 years had somehow suddenly broken and needed to be fixed. There were legislative anecdotes up in Hartford when I was president of CTLA, and around the country how doctors were fleeing states in droves because of the high cost of malpractice insurance due to these enormous runaway verdicts. None of it was true. But it led to a spasm of bad legislation, such as caps on damages. That's where legislators in a state capital somewhere, far away from an actual case, somehow, some way decide that they know better than a local jury about how much money would compensate a little girl who's paralyzed or a young mother who's killed. And they limit the amount of money that can be recovered. So the first prong of this attack was the legislative attack. The second prong was more insidious, and it was really a public relations campaign, a battle for the hearts and minds of the American people, a battle to make people think that the system really was broken. And so there are catchphrases. I can say the first word and you'll say the second, and we'll all know what we're talking about. I say frivolous, you say lawsuits. I say greedy, you say trial lawyers. I say runaway, you say verdicts. Now, none of that's really true. There are mechanisms in the system that have always been there to deal with any case that's non-meritorious, to deal with any verdict that's excessive or, for that matter, inadequate. But the fact that it's in the consciousness shows how this damage has been done. When we give tours at the museum, people come in and ask about, what about all these frivolous cases? And one of the cases that we have is the McDonald's case, Liebeck versus McDonald's, the hot coffee case, which wasn't frivolous at all. And visitors are sort of educated and they come to a new appreciation about how well that case actually worked. But then I ask them, what about these other frivolous cases that you're alluding to? And they can't name any. But the mere fact that it's in their mind shows how persuasive and powerful this assault on tort law has been. With the result that people, I think, are reluctant to exercise their rights, are timid. When I practice law, they would come and say, well, I don't want to sue, even though they've been horribly injured. This attitude fosters skepticism and cynicism on the part of juries, and it results, as Ralph just alluded to underutilization of tort law. Studies have shown that only 1 in 7 cases of medical malpractice are even reported, and only a small percentage of those ever go to court. So I think it's important for the well-being of all of us that people have a better understanding and appreciation of tort law and trial by jury and how it works. I cannot stress strongly enough that tort law benefits all of us, directly for compensating the injured victim and the families, indirectly in resulting in safer business practices, safer products. The American Museum of Tort Law, which, as you can tell, I've mentioned 14 times, check us out, website, come and visit, was created to really fill a need that I think has been vacant for too long, which is accurate, authentic, dispassionate reporting about tort law, how it works, how it benefits us, aimed squarely at the public. There are other organizations that deal with the legislative attacks on tort law, but until the museum was created, there has been no institution aimed at educating people. And from our limited experience in 1 year of operation, it really works. Thousands of people have been through the museum and come up with a real appreciation for the law and how it works and how it benefits them. So here's my closing sentence, which is a poem. Here's what we need to remember about our rights. If we don't want to lose them, we better learn about and use them. Thank you very much.